Hey out there, legal warriors. In this video, I'm going to cover 3 myths about domestic violence cases in Washington State. And these are some really common myths that it's important that we get out of our head if we're going to have a good outcome in this type of situation. If you're interested in this area of the law, stay tuned. This is the video for you. My name is Attorney Lance Fryrear. I'm a defense attorney in Linwood, Washington. My law firm's been defending people charged with crimes all throughout Washington State for more than 20 years, and I'm putting out these videos to help educate the public. So if you find this useful, please like and please subscribe. More people get to see it. More people get the help they need. Now I'm just going to jump right into it. What are the 3 big myths that I see that hurt people that are accused of crimes of domestic violence in Washington State? And if I were to back up for a second, what do I mean by a crime of domestic violence? Well, in Washington State, there are different types of crimes that are codified in the Revised Code of Washington, RCW. And the funny thing is, there is no actual crime entitled domestic violence. Domestic violence in Washington State is a designator that gets tacked on to certain types of crimes when they are involving 2 people that have a certain relationship as defined in the law. And that relationship is called a family or household member. So if someone gets into a shoving match at a bar with someone they're not related to, someone that's not a family or household member, that would be assault in the 4th degree. That's a certain law in Washington State. Now, if that shoving match in the bar is with your brother, your sister, your partner, your parent, someone you've lived with currently or lived with in the past, that's still assault in the 4th degree, but now it's a crime of domestic violence. Assault in the 4th degree, domestic violence. And so it's important that we sort of start there. So if we get charged with the crime of domestic violence, that's going to allow the court to do certain things that makes it much harder on the person charged, the defendant. The court can set a no-contact order that keeps the defendant from having any contact with the protected party, usually keeping the defendant from the protected party's home, so you get thrown out of your home. They can restrict your gun rights. There's a longer period of jurisdiction on the person charged with that. And in most cases, if the crime is a crime of domestic violence, it requires a mandatory custody arrest by the police officer. So they can't just take a report if the crime happened within the last 4 hours. If the crime happened within the last 4 hours, it's a crime of domestic violence. Law enforcement officers must make an arrest, and we cover that in one of the videos we have on this stage, on this channel, the 4-hour rule. So, what are the myths then? And the biggest number 1 myth that I see that hurts people is that the defendant thinks that the victim can just drop the charges. If I had $1 for every time someone said that, well, I could probably retire at this time, though I still wouldn't probably retire because I want to help people, but let me tell you, that's how common that claim is. Now, we have to think why people get this wrong, because people think, well, the victim pressed the charges, therefore the victim can drop the charges. Well, in Washington State, the system doesn't really think about the victim pressing charges. The alleged victim somehow usually is the one that gets law enforcement involved, not always. Law enforcement investigates the allegations of a crime, either made by the victim or someone observed something going on, and then law enforcement is the one that initiates the criminal prosecution based upon their investigation. The victim in a domestic violence case in Washington State cannot drop the case because it's not their case to drop. The plaintiff is not the victim. The plaintiff is the prosecution agency for the jurisdiction where the event is alleged to have happened. When I say jurisdiction, I mean the geographical jurisdiction. If something happens in the city of Seattle, a domestic violence case there would be the City of Seattle Prosecutor's Office. Unless it was a felony, then it goes to the higher level, the County Prosecutor's Office. If it happened in the City of Linwood, on a non-felony, it would be the City of Linwood Prosecutor's Office would be the plaintiff. It would say City of Linwood versus defendant, not alleged victim versus defendant. And so they are not a party to the case. And the only people that can drop a case would be the party to the case, the prosecution, or if the judge ruled that the prosecution or the police did something really wrong, the judge could throw out the case over the objection of the prosecutor. But what we don't have is the victim does not get to just drop the case. It is not the victim's case to pursue or to drop. Well, doesn't it matter? Doesn't it matter, Lance, that if the victim is on my side, won't that help? Absolutely. It will help the case, but so many times people suffer under the illusion, well, they're just going to drop the charge. And the prosecutors are deaf to that, right? I was a prosecutor for 7 years. If I was prosecuted 100 domestic violence cases, 98 of them probably the victim wanted the charges dropped, right? Because that's sort of, either the cycle of domestic violence, or sometimes, the case may be a little bit different than the classical case we think of about that type of charge. And so the prosecutor doesn't typically just go, oh, the victim wants to drop it, I'm just going to drop it, because that's not their job. It's not the prosecutor's job to let people go. It's the prosecutor's job to respond to the case in some way. And in responding to the case means they want to try to make sure that they're not going to see this defendant again. Now, there are different prosecutors that think about things differently. And if you have a really experienced criminal defense attorney, they may know that certain jurisdictions and certain individual prosecutors may be more willing to let a case go and may say, well, if they don't care, I don't care. But that's more the exception than the rule. And so what we have to realize is we don't want to make that mistake. Well, the victim can just drop the charges, everything's going to be fine. Because if we think that way, then the defendant makes some big mistakes. So just relax, right? They don't get an attorney. They labor under this misbelief. All of a sudden, bad things happen to them in court. They don't do steps they need to do to try to make the case go away. And then they just get angrier and angrier. Well, why is this case still going on? They don't want to pursue it. And they get angrier and angrier, and things go poorly. So please don't fall for that myth. The victim cannot just drop the charges. Man, I wish that the victim could in my line of work, because my job would be a heck of a lot easier. So, what is the second myth when it comes to a domestic violence charge that I see? Well, people get charged with domestic violence and they say, but there's no hitting, there's no pushing, there's no shoving. So the myth is that violence is the only form of domestic violence that can be prosecuted. And that simply is not the case. Remember, domestic violence isn't a charge. It's a designator on other charges. What's a situation where we see people accused of a crime of domestic violence that didn't involve violence? Well, harassment, right? Harassment in Washington State is basically making a verbal threat to harm somebody or harm their property. So it's like, hey, I'm really mad because you did this to me. I'm going to break out your car's windows. Okay? So is that violent? Well, it's a threat. You got mad, but you didn't break the car's windows. You didn't go near there. But if the alleged victim thinks that you're going to do that reasonably so, then the law says that's a crime of harassment. And we have videos on harassment here also, but harassment is a law that basically says, hey, if you make a threat against somebody and that person who had the threat against them, if they reasonably believe that threat may be carried out, then in certain circumstances, threat to harm persons, property, stuff like that, then that's a crime. And if that's a family or household member, that's a crime of domestic violence. And we go through all the same problems, no contact orders, extra jurisdiction, loss of gun rights, DNA samples, all these things can happen. Also, if someone has an order against you, right? They have a protection order against you, something like that. It's a family or household member, and they allege you violated the order, right? A phone call, an email, you accidentally drive by someplace where they happen to be at. There's no violence involved in that, but yet if the authorities believe it happened, you're going to get arrested and or charged with the crime of domestic violence. A protection order violation, DV, no contact order violation, DV, those type of things. So that can also, if we fall for the myth, what happens? If we fall for the myth that thinks, hey, because there's no violence, I can't get in trouble for this type of thing. Again, it makes us less cautious. It makes us not do the things that we need to do to try to protect ourselves. And it also adds to that level of victimhood that we feel and anger we feel. And then it just freezes us in place, because if we're accused of doing something wrong, the most important thing we can do is move and do some things to start to improve our position so we can try to get out of this mess as soon as possible. And that relates to myth 3, as soon as possible. The biggest other myth that I see is that this is going to go fast. This is going to be done quickly. And why people think that, I don't know if they think it, but maybe it's more I want that, because of how terrible it is to be the person accused of this, because this type of charge disrupts your life to such a degree. And I'm a defense attorney. I'm not talking about all the bad things that have happened or may happen to people that are the alleged victims in these situations. I'm not going to discount that. But from the defense attorney's point of view, when we're talking about a person accused of this, that person's life is also turned upside down. They may not have their phone. They may not have their wallet. They may not have any shoes. They may not have any pants. They may not have anything when they get released from the jail except what they got arrested in. They got arrested in their robe, and they still have their robe when they get out. And there's going to be a no contact order that says they can't go home. Also, they may not be able to see their children, right? They may not be able to get the stuff they need for work. And so there's this urgency. This needs to go fast. Doesn't the court understand? Doesn't the prosecutor understand what I'm going through? And the victim doesn't want these charges anyway, right? They want them dropped. So I should just go live at home. Nothing's going to happen to me. This is going to be over quick. And the fact is, things don't get over quickly. And what do I mean by quick? An average domestic violence case, I mean, if it's a city case, the quickest thing you could possibly likely imagine is 3 months, and more like 3 to 6 months for most city cases before we have a known resolution. State case might be 6 to 12 months. Felony case might be a year to multiple years. Again, your mileage may vary, but these are general examples of what I've learned from doing this for more than 30 years on both sides of the aisle. So what do we do, right? If we bust the myth that this is going to go quickly, what do we do? Well, we need to plan for the long haul, right? We need to plan that, hey, maybe I just don't need to get a hotel for a week, or I don't need to go flop on the couch of my friend for a week, or my brother or sister who really doesn't want me there. If we have the resources, maybe we think, well, what can we do? Can we get a month-to-month rental? Can we get a month-to-month room? What can we do to prepare for this to go on longer than makes sense? Right? So many times, us reasonable people out there in the world think, hey, logically, this is how something should work. We should get together, we should talk it over, the court should see I don't have any priors, we could see that, hey, no one got injured, that type of stuff. And that's simply not what they're interested in the court system. Every person in the court system is interested in surviving their own role, right? The prosecutor's got every case in the courtroom. The judge has every case in the courtroom. The public defender's got, 70% of the cases in the courtroom. One of your advantages of a private attorney is they've got a handful of cases, so they can try to give it more attention and make those in the system give it more attention. But the people in the system will still only give it attention at a certain time when they're able to, right? If a prosecutor has got 1,000 cases and they've got 200 of those cases have been around for 8 months, and the judge is not going to let them continue it anymore to try to get a resolution as they're trying to survive. Basically, the prosecutor is more receptive to those older cases, looking at those and spending their limited energy than the case that just happened, right? And so your attorney will know when and how to approach the people making the decisions in the case to try to get the case over with as quickly as possible, but most importantly, with as little risk as possible. We can get that case over with quickly. We could get a trial set within 90 days if we wanted to. But a really great attorney doesn't want to subject their client to the risk of the jurors just believing whatever the police say. Because guess what? People like to convict people. That's why everything we see on TV almost always is a conviction. How often do you see a not guilty? Not nearly often enough. So those are the 3 myths I wanted to cover. By living with those myths in our head, we really hurt ourselves. By not doing the things we need to do, by being impatient, by being angry, things that aren't going to help us get the result we need and aren't going to help us live in peace while this is going on. And so I want us to avoid those. So if you found this useful, please please subscribe. More people get to see it. More people get the help they need. And more importantly, if you have a criminal matter in Washington State, any type of criminal matter, including a domestic violence matter, feel free to reach out to our firm. We've been doing this for more than 20 years. If we get on board, we'll listen to what happened. We'll identify a way forward. We will be there for you. Thank you.